Hi, everyone. Good afternoon. Carl Steinbeck here. Just want to touch bases on what we have going on with Judge Cannone in the Massachusetts versus Karen Reed case. I've been very much frustrated and very concerned about the hijacking of justice up there for Karen Reed. The fact is, there's not really much of a semblance of a constitution in play there in that courtroom. The judge does have to follow by rules, or is supposed to follow by rules of how she conducts her courtroom. And when you look at these canons, as they call them, which are principles that judges are supposed to follow, there's subsets of the canons called rules. And if there's rules that are being violated, judges can have actions taken against them by a review committee that ultimately notifies an informal complaint process to the judge, and the judge can respond. And ultimately, if there's not some kind of agreement, it can go up to the Supreme Court for action. So I think that a lot of this stuff is not really amounting to much in terms of what they're willing to do to hold judges' feet to the fire and hold them accountable and stuff. And a lot of the stuff is held in confidence and not disclosed to the public. So you don't really know what complaints were made against what judges. There's some examples they give you in an annual report. So what I'm going to do first is show you an annual report for 2023. And that was not done until September 24. So last year's will not be done until probably September of this year. So 2024's state of the judiciary and their compliance with these judicial canons and rules is we're not going to find out till after this trial is over. So here's what we have on the mass.gov website for the judiciary. You can see it's a mass.gov/doc/CJC-annual-report 2023/download. So that is where you could find it. You could just Google this title here and you could find it yourself. But in any event, I want to scroll through here, just this introduction. And it talks about in how the legislature created the Massachusetts Commission on Judicial Conduct, here and after the commission in this document, in 1978, and entrusted it with the important mission of enforcing standards of judicial conduct for Massachusetts state judges, promoting public confidence in the judiciary, and preserving the integrity of the judicial process. So here it shows that the state, at least on paper, has an interest in promoting public confidence in the judiciary. I've been seeing nothing but complaints from this judge since I've been covering this case, and you guys are right and are correct in that this is really the worst judge you could ever face in a trial proceeding. And this is a murder case, and it's everything the judge is doing for the most part. You can tell she can't stand the defense. She can't stand Karen, and she wants to do everything she can with her black robe on to aid and abet the prosecution of Karen Reed. So her and Hank Brennan are in an alignment, and we'll talk about that more later. But the membership of the commission consists of 9 people, each appointed for an unpaid 6-year term, 3 judges appointed by the Supreme Court, Judicial Court, 3 lawyers appointed by the Chief Justice of the trial court, and 3 non-lawyers appointed by the governor. So all these people are appointed. They all have political connections, right? And they're pretty much all going to be the same party. So it's sort of like having one party police itself. The commission is the designated forum in Massachusetts for all complaints alleging misconduct by a judge or alleging mental or physical disability affecting the judge's performance. And then here's a part that I wanted you to see. Anyone may file a complaint with the commission, a party in a case, a lawyer, another judge, or an interested citizen who believes a judge has committed misconduct or has a disability affecting his or her ability to serve as a judge. It says the commission continually works to take appropriate steps to make itself accessible to the public. Complaints may, of course, be submitted to the commission's office by regular mail and hand delivery or by facsimile. And then in 2015, they say develop the use of a website to file a complaint. And then it says here, what constitutes misconduct by a judge is already defined by the Massachusetts Code of Judicial Conduct, also known as the Supreme Judicial Court Rule 3:09. Judicial misconduct under this code can include, but is not limited to, a judge creating an appearance of bias. So you don't even have to be actually biased against a party or an attorney, comma, treating a party discourteously. Wow, that's interesting. Failing to give all interested parties a full opportunity to make their arguments. We've seen that, haven't we? Or failing to make a decision in a prompt and efficient and fair manner. And we can get to that because she still hasn't described how, other than making a declaration, how the defense has violated reciprocal discovery. Under the rules that govern its operation, the commission must conduct a commission screening into or investigate any complaint that alleges specific facts that, if true, would constitute misconduct. This investigation or commission screening is conducted by the commission staff, which includes 4 full-time lawyers. So they got 4 full-time lawyers just screening judges up there. That sounds like a really robust office. Do they have that much allegation pending of misconduct? And then it goes on, it talks about the experience, not just as a lawyer, but as a petitioner in the courts of the Commonwealth. Each of the lawyers has considerable experience to bear in conducting the commission screening or investigating a complaint. Then it goes on, the next paragraph, to say, if the membership of the commission concludes that a complaint lacks merit, there is no evidence of misconduct, then the matter will be dismissed. In that event, both the complainant and the judge receive notice of dismissal, and under most circumstances, the complaint will remain confidential. If, however, the commission finds that the complaint has merit, it may reach an agreement with the judge to dispose of a complaint through an informal adjustment, which may include either public or confidential discipline. The commission and the judge may reach an agreement to make a confidential Commission Rule 13 submission to the Supreme Judicial Court, which may also include either public or confidential discipline, or the commission may vote that the complaint should proceed to formal charges, and those charges and hearings on those charges are nearly always public. The commission is not a forum for a complaint that a judge's decision in a particular case was incorrect. Judges are rightly entrusted with a broad discretion to interpret the law and or decide what evidence before them should be credited and taken as true. Many complaints are filed with the commission by parties who are disappointed with the result of their case and believe the judge was not fair and that his or her decision was wrong. Hardly a judge in Massachusetts escapes such claims throughout his or her career on the bench, and the commission's examination of complaints regarding a judge's decision is limited to allegations that a judge violated the code or made a legal decision in bad faith or based on a corrupt motive. If a party alleges that the judge has misinterpreted the law or evidence, the proper forum for a remedy includes the appellate court, but does not include the commission. So here we have a situation where, for Karen Reed, this is the judge not following the law and all that. That's not going to get these charges dismissed. The only way she can do that if she's found guilty is through the appellate process. This is a totally separate process here. It has no impact on the case. They're not going to overrule something that the trial court does on a particular case. They could make findings on a particular case. They could make findings that the judge is not comporting with the canons and the rules, but that's limited to that particular judge. Is not going to be able to be then brought in on appeal and say, hey, this commission found that, let's say Judge Cannone, for example, violated numerous canons, and therefore this should help give some kind of benefit and redress for Karen Reed. So this is a totally different thing. I don't have a lot of faith and confidence that this will actually really holds judges' feet to the fire and holds them accountable. Anyway, I'm just showing you what this process is about. There's a mechanism for making complaints. So with that, let's go ahead and now look to let's see what these actual rules are. I showed some in the live stream either last night or the night before. So here, this is the website, mass.gov. So if you just Google file complaint against Massachusetts judge or MASS judge, this page would probably pop up in a Google search. And then you can just see what the search around, see what this is about. They have a preamble here. And they talk about an independent, fair, and impartial judiciary is indispensable to our system of justice. The United States legal system is based on the principle that an independent, impartial, and competent jury composed of persons of integrity will interpret and apply the law that governs our society. Thus, the judiciary plays a central role in preserving the principles of justice in the rule of law. The rule of law is so important in any civil society. If you don't have the rule of law, you don't have a civil society at all. You basically just have thug and mob rule. That's my comment on it. And then it goes on to say, inherent in all the rules of this code are the precepts that judges individually and collectively must respect and honor the judicial office as a public trust and must strive to maintain and enhance confidence in the legal system. I stress that, confidence in the legal system, okay? If we don't see a judge treating a party fairly, that's eroding trust in the legal system. And if you don't have trust in a legal system, then you don't really have a lot of ability to feel good about society and how your taxes are being paid to represent you fairly in the event that some citizen tries to treat you unfairly or some kind of business tries to treat you unfairly. It goes on to say that judges should maintain the dignity of judicial office at all times and avoid both impropriety and the appearance of impropriety in their professional and personal lives. So a judge, that's sort of like in the military. What you do on the clock when you're in uniform, as well as what you're doing off the clock, out of uniform. In this case, you're not wearing your robe. All that has an effect on whether the public can have confidence in you being a neutral arbiter of justice and not coming in there with any perceived and actual biases and prejudices. And so this is, it goes on to say they should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. So all these things are brought into question in this trial when we look at what's going on with this judge. The Code of Judicial Conduct established standards for ethical conduct of judges. It's not intended as an exhaustive guide for the conduct of judges who are governed in their judicial and personal conduct by general ethical standards as well as the code. But the code is intended, however, to provide guidance and assist judges to maintain the highest standards of judicial conduct and personal conduct and to provide the basis of their conduct through disciplinary authorities. So that's the preamble. The scope of this, it talks about how the Code of Judicial Conduct consists of 4 canons, numbered rules under each canon, and the comments that follow and explain each rule. And then there's the scope and terminology sections provide additional guidance in interpreting and applying the code. And it goes on to say here the canons state overarching principles of judicial ethics that all judges must observe. All of them must observe it. Although a judge may be disciplined only for violating a rule, the canons provide important guidance in interpreting a rule. So as I said earlier, you can get in trouble as a judge for violating a rule, but not the overall arching canon, because that's more of a principle to follow, and it's not as specific and exacting to find a violation. Where a rule contains a permissive term, such as may or should, the conduct being addressed is committed to the personal and professional discretion of the judge, and no disciplinary action should be taken for action or inaction within the bounds of such discretion. It goes on to say the comments that accompany the rules serve 2 functions. First, they provide guidance regarding the purpose, meaning, and proper application of the rules. They include explanatory material and in some instances provide examples of the permitted or prohibited conduct. Comments neither add to nor subtract from the binding obligations set forth in the rules. Therefore, when a comment entombs the term must, it does not mean that the comment itself is binding or enforceable. It signifies that the rule in question, properly understood, is obligatory as to the conduct at issue. And then it says, second, the comments identify aspirational goals for the judges to implement fully the principles of this code as articulated in the canons Judges should strive to exceed the standards of conduct established by the rules, holding themselves to the highest ethical standards and seeking to establish those aspirational goals, thereby enhancing the dignity of the judicial office. So you're supposed to go higher than what you possibly can even find in the rules for maintaining your integrity in the system, because optics matter. Public perception of how you conduct yourself with that robe on does matter. That's an important thing. The rules of the Code of Judicial Conduct are rules of reason that should be applied consistently with constitutional requirements, statutes, and other court rules, decision laws, and with due regard to all relevant circumstances. And it says that the rule should not be interpreted to impinge upon the essential independence of the judges in making judicial decisions. Although it is the black letter of the rules that is binding and enforceable, it's not contemplated that every transgression will result in the imposition of discipline. So they have all this leeway here. Some conduct that literally may violate a rule may not violate the policy behind the prohibition, or violation may be de minimis. Whether discipline should be imposed should be determined through a reasonable reasoned application of the rules, and should depend on the factors such as seriousness of the transgression, the facts and circumstances that existed at the time of the transgression, and the extent of any pattern of improper activity. Any pattern, well, that would be interesting to note. Whether there have been previous violations of the effect of the improper activity on the judicial system and others. The code is not intended to be a basis for civil or criminal liability, so no one can sue a judge for not following these. Neither is intended as a basis for litigants to seek collateral remedies against each other or obtain tactical advantage in proceedings before a court. All right, so now let's look at Canon 1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. And here it says under 1.1, the judge shall comply with the law, including the Code of Judicial Conduct. So this is talking about following the law. The judge's obligation under this comment has an obligation to comply with law. Ordinarily includes an obligation to comply with state conflict or interest law. That was raised by the defense previously. The judge denied that she had any conflicts on that with regard to some of the witnesses for the prosecution. It was not brought up about her relation with Morrissey and connections through their mothers, and whether that was the premise of how she was able to have a promotion to a judgeship out of a public defender office, which is really a weird stepping stone up from being a public defender to a judge. It's not very common. So Rule 1.2 says a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid the appearance of avoid impropriety and the appearance of impropriety. So again, just the appearances of that alone are enough to cause a problem here, right? So when the judge is not following the law and not looking at Supreme Court case law that's binding on how evidence should be coming in for a litigant, then you're not following the law. If you're not treating the litigants fairly, that's not showing that you have the proper temperament and the proper fairness and decorum in your courtroom. So it says this other stuff isn't really applicable here. Public confidence is eroded in the judiciary by improper conduct and conduct that creates an appearance of impropriety. This principle applies to both the professional and personal conduct of the judge. So how the judge is acting in the courtroom, how she's treating the defense and treating defense witnesses like the ARCO experts, Dr. Wolf in particular, you're not promoting confidence in the judiciary, right? It just looks like something that's not consistent with the rule of law. It's not consistent with tipping your hand in one favor over the other. The scales of justice are very much being weighted down in favor of the prosecution. The prosecution is never talked to the same way as the defense counsel. The prosecution can do anything late they want, and this judge has no concern, no iota for that. Defense, the prosecution merely has to say, oh, they must have some emails or texts I'm not getting, and they just create this hype drama, and the judges automatically buys into it it makes it look like logistic texts are an issue of integrity for the defense and their expert. It's just complete smoke and mirrors nonsense. And any attorneys that practice law in a court of law, they know exactly what's going on here. It's all a dog and pony show. All right, so with that, number 1.3 also says avoid abusing the prestige of the judicial office. A judge shall not abuse the prestige of the judicial office to advance the personal or economic interests of the judge or others, or allow others to do so. Okay, this is more like outside of the courtroom, trying to get favor because you're a judge. If you get pulled over like for speeding or something like that, you're not supposed to show the fact that you're a judge as a reason to get out of a ticket. I don't know if they have judicial license plates. A lot of states do that here in the United States. But anyway, in terms of promoting confidence in the judiciary, the way she's acted and treated the litigants, I would say let's go to the scorecard here. I guess we don't have that one on here. So, all right, I'll skip that one. But Canon 1 is, I would say she's not promoting confidence in the judiciary. So I'd give her an F on that. All right, let's go to Canon 2. Canon 2 says here, a judge shall perform the duties of judicial office impartially, competently, and diligently. Let's go to, and then they got all these different sub rules here. All right, so let's go to the first one here, giving precedence to the duties of judicial office. The duties of the judicial office, as prescribed by law, shall take precedence over all other judges' personal extrajudicial activities. To ensure that judges are available to fulfill their judicial duties, judges must conduct their personal and extrajudicial activities to minimize the risk of conflicts that result from infrequent disqualification. And then I'll jump on to comment 3. With respect to time devoted to personal and extrajudicial activities, this rule must be construed in a reasonable manner. Family obligations and illnesses and emergencies may require judges' immediate attention. Attending those obligations and situations is not prohibited by this rule. Okay, but do you really give preference to judicial duties when you start court all the time late and you have all these extra long delays and breaks? Some of them could be sidebars, but it just seems like there's exceedingly great number of breaks. And they also don't start till 9 o'clock, and they also finish at 4. So the lunch break is not that long. It's usually 45 minutes, but then it tends to extend over longer because of other issues that come up. So, and then with Fridays off, there's no court on Fridays normally. I guess tomorrow they're having court because today they're not, because a juror needs surgery. So anyway, it's just sort of like this thing is being strung along a lot longer than I think it should be. So I would say right here, based on her not having really a tightly run ship in the courtroom there, that's my grade. Do you guys have any comments on that one? I'll hold off here. If you guys have any comments on this one, what do you think? What score would you guys give her? Yeah, the recusal process does not happen through this commission. You have to do that through the judge. Yeah, if Judge Cannone's on this committee, then she'd have to be recused. And so those are her co-workers, I guess. So yeah, imagine that. Yeah, we don't have any complaints from last year from this trial, so we don't know. They wouldn't mention it by name. They'd only mention the number based on the type of judge she is, which she's a Superior Court judge. Learning curves, you're saying everything she does written down, so they're taking note of her misconduct. Well, they're not taking note unless there's a complaint out there, and they have to specify what the complaint matter is about. Okay, James Jameson, I'd sack her for timekeeping alone. Yeah, I've never seen a court. I mean, you got a lengthy trial. Most trials, criminal trials, are no way this long. So, and yeah, she's a momentum stopper for the defense. It's so blatant. So that sort of it falls under a different rule. So we'll cover that as well. Lily Rose, will I make a complaint myself? Yes, we're going to talk about that later. Yeah. Yeah, I think this is correct. I did not hear that she was on this one. There's other committees, judiciary committees. She's on a committee that helps review discovery rules. That's what I recall it being. So I don't think she's on both of these. That one helps the Supreme Court come up with new rules and maybe makes recommendations to the legislature. M. Fetters, you're saying these complaints go nowhere. Believe me. Okay, Annie Level, you're saying Mark Betterow, another channel. He talked to other Massachusetts judges who say Bev is a disgrace. Judge Cannone is a disgrace. Learning curves. Can lawyers band together and ask for removal? You know, it's a one-party system up there for the most part. So I don't know that the lawyers really want to be in a position. It's not their client, and I don't know. Maybe they look the other way because they don't want to. They don't want to upset the apple cart. Ann B says, find any board or organization the attorney belongs to, complain on every level. Mar, nothing's being done about Judge Cannone. Sam, you're asking, is it possible to have a petition online so everyone can sign? I don't know if that really matters. They have an online thing where everybody can individually do it. So, all right. So with that, I'm going to go ahead. Let's go back to so that's the first one, 2.1. Let's go to the next one. 2.2, impartiality and fairness. A judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. So how do we have this Judge Cannone acting fairly and impartially? Every day you see how many minutes have to elapse before you see her doing something that looks like she's favoring the prosecution? Everything about body language, the way she talks, the way she rules, everything shows that she's totally in cahoots, if you will, with the prosecution and is actively resisting the defense. She doesn't come across neutral at all. It says when applying and interpreting law, a judge sometimes may make good faith errors of law or fact. Errors of this kind do not violate this rule. I would say that in looking at her rulings, they're so one-sidedly worded. She's making findings like in the third-party culprit opinion she gave. She basically is making all these findings that are of fact, but it's something that the jury should be deciding, not the judge. So she's basically taken away the ability of the defense to present facts. She's making a pretrial ruling of evidence that's not even been presented yet. And so she's very much limiting to the two Bryans cross-examination on them and being third-party culprits. And she's completely taken Colin Albert from being accused of being a third-party culprit in their opening. So this whole thing is so sketchy that the defense could not even bring up third-party culprit in essence in their opening. Not that they needed to, but when you got a judge hijacking this way, it's really terrible. And applying interpreting law, is she applying the law properly? No, she's not allowing many of her rulings, whether it's on objections to whether it's allowing admissibility of experts and the treatment of experts. All this looks abundantly against the defense and Karen Reed. And so on this particular rule here, here's what I grade her. This is about an F. This is, I mean, if you gave a scale lower than an F, this is how this one would be. You won't find a more biased judge on impartiality and fairness. And bias is sort of the same kind of thing. Impartiality and fairness is not so much as like you're against the party, but you're sort of siding with one another. Bias is more like you really don't like them. It's very much a strong opposition. And that's what I'd say we have here is a strong opposition. So moving on to 3 here. 2.3, bias, prejudice, and harassment. A judge shall perform the duties of judicial office, including administrative duties, without bias, prejudice, or harassment. This particular one, think about how there's prejudice and bias in about everything she does. I mean, you cannot escape the fact that anyone looking at this as a neutral observer, that's how I was in this particular case when I first started looking at it from last year. I'm like, wait a minute, this judge, I came in there neutral. I'm like, I don't know anything about this case. I want to look to see whether there's any evidence there to support these charges. And just what is abundantly clear to me was the way the judge was conducting herself in trial 1 was not something that you would expect to see from a judge, especially a judge on a murder case. So the it says under Part B, a judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice or engage in harassment, including bias, prejudice, or harassment upon a party's status or condition. A judge shall also not permit court personnel or others subject to the judge's discretion or control to engage in such prohibited behavior. So that would include the prosecutor. So what she's doing is allowing words and conduct of her to manifest bias and prejudice and actual harassment against the defense and their witnesses, specifically Dr. Wolf, by her also allowing Hank Brennan to berate and verbally be abusive and harassing towards Dr. Wolf. So the judge has violated this plain and simple. And this is basically, it goes on to say specifically lawyers. A judge shall require lawyers in proceedings before the court to refrain from manifesting bias or prejudice or engaging in harassment against parties, witnesses, or lawyers, including bias, prejudice, or harassment based on a person's status or condition. So I would say that manifesting bias, prejudice, engaging in harassment, that's sort of what you're talking about with the way that the witness, Dr. Wolf, was treated. I mean, just it was just an embarrassment and a disgrace to see the way he was treated. Look what it says here on the comment. A judge who manifests bias or prejudice or engages in harassment in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. A judge must avoid words or conducts that may reasonably be perceived as manifesting bias or prejudice or gaining in harassment. So anyway, we don't have a judge that's like making fun of Karen and her disability. It says here like disability is one of the ways that you can be in violation, but just the mere status. I mean, I don't know if it's because of her gender, but in any event, this judge, plain and simple, is showing bias, prejudice, and some forms of harassment almost on, I would say, on a daily basis. If not, I would say, man, you can probably see it almost on does even an hour go by where you don't see one of these things occurring? So based on that, let's go back to the scorecard. Gets another F there. Okay, now we're going to go on to 2.4, external influences on judicial conduct. That one really doesn't apply here. A judge shall not prevent family, social, political, or financial or other interests in relations to influence judges. I guess this one here, the connection, that's not been established on the record, though, her connection with D.A. Morrissey through their mothers. Is that how she got political ties to become a judge and be appointed as a judge? Not sure. So I'll skip that one. Competence, diligence, and cooperation is the next one. A judge shall perform judicial and administrative duties competently, diligently, in a timely manner. So again, this sort of ties in with the first one, so I won't grade her on this, but her competence in terms of like following the Constitution, that would be something that she would get an F on, but I'm going to skip that one. And we're going to jump on to 2.6 here. RK, stand by. Okay, let's go on to 2.6 here. Ensuring the right to be heard. Isn't that an interesting one? A judge shall accord to every person, including Karen Reed, mind you, who has a legal interest in a proceeding or a person's lawyer, that person's lawyer. So that would include the defense team, including Alan Jackson and Robert Alessi, Dave Yannetti, the right to be heard according to the law. A judge may make reasonable efforts consistent with the law to facilitate the ability of all litigants, including self-represented litigants, to be fairly heard. So that particular one, the may, means they can't enforce it, but reasonable efforts to be fairly heard. Well, that sort of like waters down the first one, which says a judge shall, according to every person who has a legal interest in a proceeding or that person's lawyer, the right to be heard according to law. Well, there's constitutional case law. She's under the U.S. Supreme Court determinations that she's violating in a number of areas that I've pointed out in previous videos, live streams. And look what it says here about the right to be heard. The right to be heard is an essential component of a fair and impartial justice system. Substantive rights of litigants can be protected only if measures protecting the right to be heard are observed. Right there. Where do we have this judge ruling on the issue of defense bringing a expert law enforcement officer retired to testify about what a botched investigation we had on this murder case of John O'Keefe? The government can bring in a whole litany of law enforcement officers and the defense can't bring in a single one. How is this a fair and impartial system? It's not. This is about the worst grade you could get. Her ruling on that and the way she's almost was trying to keep out ARCA. I think ARCA was probably some pressure received because of the fact that the feds were monitoring what was going on this whole trial through ARCA experts, keeping them informed of what's going on. That I think is probably the main reason why ARCA is allowed to testify, because the judge is worried about this corruption thing blowing up in all those folks' faces. All right, so with that one, rights to be heard, I don't need to go any more on that. So on that particular one, that's about as bad of a score as you can get, like an F, triple F minus or something like that. So, all right, moving on here then, we have next one is going to jump on at 2.8, responsibility to decide, not really applicable. 2.8, decorum, demeanor, and communication with jurors. All right, sorry, I'm losing my space here. 2.8. A judge shall require order and decorum in proceedings before the court. How do you have order and decorum in this court? Look at what Part B says. A judge shall be patient. We've seen her lose patience many times at the defense. She starts blasting at them, saying they have intentionally violated reciprocal discovery and words to that effect. That doesn't demonstrate patience. Dignified, does she treat them with any dignity and respect? No. Is she courteous to the litigants, jurors and witnesses, lawyers, court personnel, and others with whom the judge deals in official capacity? So her whole court doesn't even seem like a real court. The way her body mannerisms are, the way she's just up there moving around all the time, looking at stuff on her screen, touching her hair, swinging her glasses around, sighs, all the sighs you hear on the microphone. I mean, this is not a kind of court you can have any kind of real respect for. And then look, this goes on to say, and shall require similar conduct of lawyers, court personnel, and other subject to the court's direction and control. We've seen this kind of language before, subject to the court's direction and control. So how did Hank Brennan treat Daniel Wolf with dignity and courtesy, right? He's not even coming close to that. So this one here, the whole decorum of this court is not professional. You don't have a sense that things are running by the book, that the rule of law really applies. It's more like, which side is a judge favoring? That's sort of the feel that you get in this courtroom. John's custom saws. Yeah, the only way she can really get a fair trial, unless there's enough complaints that make it to this committee and they decide to do something about it, maybe she'll feel some pressure that way. But who knows about that? Missy Cohen. Wouldn't it make more sense to have a new judge after a mistrial? She had 2 mistrials in a short period of time, both involving law enforcement. She's not a good judge. Her competency is not there. The jury instructions are granted. Massachusetts have some really messed up case law, and their jury instructions, including reasonable doubt, are like from the 1840s. So they're really behind the times there, including their court technology and everything. I mean, look how old that courthouse is. They can't afford a decent courthouse because they got their cops making $230,000 to $330,000 a year. Can you believe that? What a disgrace. All right, so going back here for 2.8, another F. Stand by. I gotta jump down. I don't know why it doesn't save it here on StreamYard. StreamYard is very much not very user friendly at times. Sorry about that. Okay, so 2.8, we have an F again, and then let's look at 2X ex parte communications. Under A, it says a judge shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties or their lawyers concerning a pending or impending matter, except as follows. And then there's some exceptions here, like when there's no party will gain a procedural, substantive, or technical advantage or roles of ex parte communication. And the judge then must promptly, that's an and judge promptly makes a provision to notify the other parties of the substance of ex parte communication, gives the parties an opportunity to respond. So in other words, if I was like had a pending trial coming up and all of a sudden I had some kind of situational emergency where I was like, Your Honor, I cannot make it to this trial. And I just basically contacted the judge directly, maybe walking into his chambers, knocking on the door, walking in his chambers. Judge, could I address something real quick? And so I just need to ask for a continuance. I'll file a motion when I get back to my office, but it's a sudden emergency that came up. I need to ask for us to move the trial date. And something like that, where the judge will then call up the other side and say, hey, all right, I just had an ex parte communication. So there's none of this like advantage you get by having access to the judge that one party doesn't have, that one party has that the other doesn't. So that looks very unfair. And that's why they have this rule, and every state has this for ex parte communication as being a no-go. You're not supposed to be doing that unless there's certain exceptions. And like I say, then you got to bring it to light. So in this particular case, think about it. The way they're having the secret code, the way they look at each other, when we saw Hank up there with Judge Cannone when he was handing Exhibit 1 to Daniel Wolf, and he's shaking his head like that, and the judge was looking at him, and there was some kind of code talk going on. So this is an ex parte communication. I believe this violates the spirit of it, the intent of it. So they got some kind of secret messaging going on where the judge was supposed to report this to the court, open court. Hey, the prosecution was just shaking his head no, and how would she know what that means unless they had some other talk outside the presence of the other side? The judge obviously has some kind of code talk going on with this Hank Brennan, and this is not permitted, folks. It's not permitted at all. And so it's right there for us to see on video, and I presented that, and you guys can check that out on YouTube. Yeah, we've already covered the bias. So let's see. Let's go ahead here then to ex parte communication. So we can score that an F as well. So overall then, look at how she's graded so far in these other areas. The other areas I figured are non-applicable, so that it's not subject to a grade. So overall, this is Judge Cannone's score. And you guys can make your own call or your own determinations. I think we should jump ahead to one other matter, and that is disqualification. Under 2-11, a judge shall disqualify himself or herself in any proceeding which the judge cannot be impartial, or the judge's impartiality might reasonably be questioned, including but limited to the following circumstances. The judge has a personal bias or prejudice concerning a party or a party's lawyer. We got that clearly established. Or personal knowledge of facts that are in dispute in the proceedings. So she doesn't have personal knowledge that we know of, unless she has personal knowledge and connections to, let's say, D.A. Morrissey. The next one doesn't apply, about family relationships. A party to the proceeding would be Morrissey, all right? None of those others apply. Then it goes on to say a judge subject to disqualification on this rule, other than for bias or prejudice, may disclose on the record, may ask the parties to consider outside the presence of and with the participation by the judge and court personnel whether to waive disqualification. Of course, the defense wouldn't waive it here. But when you look at this, you can't waive bias and prejudice, okay? So she's clearly, by her mannerisms, day in, day out, throughout trial one, it's even worse now. She's not able to conduct herself in a manner that doesn't show that she has strong bias and prejudice against Karen Reed and her defense team. So with that, she should be disqualified. There should be a mistrial. She should never have been on this case. She just can't contain herself. She can't help herself. So let's go back up here then. So if you just do mass complaint, state judge, that's what you get. That's their phone number. That's their fax where they said it could receive stuff. Here's an online complaint. There you can see here filing a complaint with their online thing here. They want to know the case number, the docket number, attorneys involved, and then give a summary of your complaint here. And they can also choose to add files. I guess you could also add YouTube links to stuff the judge has done. So, yeah, I think this has gotten so ridiculous. I don't know if it's going to matter at all, but I just plan on filing something the next couple of days before the weekend. And there's some timeline, like if they start looking at this and whatnot, the sooner that complaints are filed, probably the more effect they'd have. Like I say, maybe if there's a lot of complaints being filed, that would make a difference. I would say people that are in Massachusetts have a much stronger likelihood of having their complaint taken seriously because they live there. And so you can see the address and all that kind of stuff here. But you can also provide it anonymously. It says here, please provide your email address if you wish to be emailed a copy of your complaint after it is submitted. This officer will not otherwise correspond with you by email regarding your complaint. All other communication will be by phone or regular mail. There you put the dates of the misconduct. So anyway, that's they don't leave you a whole lot there to submit, do they? I don't know if this allows you to submit it. I guess you could write it up and then it's attached it as a file. That'd probably be easier because they're not leaving enough room there. And then the other option is to use their PDF here. So you just type in your name, your address, name of the judge, specific facts. So what I will do is I'll go through the specific rules and then cite the rules and explain what's going on in court to file it. So it's something that, it's just really odd that we're having this discussion. Why can't you just have fairness? If Karen Reed's so guilty, why isn't she given a fair judge that doesn't have this outward contempt and bias towards her? I just don't get it. I've never seen anything like this. And it just looks bad. If it looks bad, it is bad. Okay. Just like with ethics for lawyers, if it looks bad, it is bad. Same with judges' conduct. If it looks bad, it is bad. The appearance of bias and prejudice is as bad as actual. So you don't actually have to have a judge that can't stand a litigant, wants to see the worst outcome for him, just completely wishes that they could punish them in every possible way in all their rulings, including up into the final ruling and opinion. Here, Karen Reed doesn't have the judge deciding her guilt or innocence. It's the judge. But when you have a judge making rulings that are keeping out the defense from doing the proper cross-examination, keeping out the experts, not letting them present a defense that they want to on third-party culprit. I mean, all this is really strangulating and binding the defense to not be allowed to be heard, and the Constitution actually requires it. So with that being said, I'll go ahead and take questions now. If you've already asked a question before, just put a red emoji in this, restart it down. So I'm going down. I have a time stamp on all the comments here. So I'm now at what, at 4:05? Two words, Dole. I would think you need to have standing to be taken seriously in a complaint. So, as a common person just watching the trial on YouTube, I don't think we should be complaining. All right, that's your call. But I can also tell you what they do talk about public perception. So, if this commission starts seeing that, hey, there's a lot of people that are complaining all over the world about Massachusetts justice, I think there's something to be said about it. If it's just one person and they complain, then yeah, it's not that big a deal, right? But if there's a mass public groundswell of support for a cause, then that can make a difference, right? Buttercup, you're saying the judge's most important job is to make sure Karen Reed is convicted. I mean, that's the impression you get. If you get that impression, how nauseating is that to see that? Yeah, this is another one, Missy Cohen. Not allowing the jurors to know the feds were investigating the investigation. That's insanity. And maybe you don't want to invest. I could see a judge saying, well, I don't want the jury to know that the investigators were being investigated. I think if I was a judge, I'll allow that. But the real kicker is not allowing ARCA to be told they were hired by the feds to conduct the tests that they did. So that's where I think that's especially because it's so misleading. The first jury thought that they were there for Karen's insurance company, and so they obviously couldn't be trusted because they're trying to avoid paying wrongful death, millions of dollars for wrongful death actions. Eva, improper selection. Judges generally don't select jury four-person in jury trials. That's usually done by jurors themselves. So a judge selects a four-person with intent to favor one side. Yeah, that's totally favoritism. Yeah, I mean, she picks the only cop on the jury to be a foreman. And look what it did. It just completely hijacked this whole process. Yeah, I played that code talk between the judge and Brennan. Yeah, Peter, first name, appearance of propriety and priority. Is it one and the same thing? Mads, you're saying Morrissey's running the show. If the Commonwealth is sure in this case, why do they play so dirty? Yeah, and I'm telling you that code talk between Brennan and her. How would they know what to be signaling unless they're talking behind the scenes outside the court hearings? That's what I want to know. How would that communication be coordinated outside the jury? If they're doing it in the trial, my instincts tell me they're doing it outside the trial. They're communicating somehow. Can't prove it, but I'm telling you, that's my instincts. How otherwise would they know how to pass messages on and how to scheme as to how to try to trample the defense? All right, Monique Rosales, Coach Mo, you're saying thank you. You have an entire army behind you if you need us to petition sign with you. Well, this is not a petition or signature. You have to actually go in there and fill it out yourself. And I leave that to you. I don't want you guys to do it just because I'm telling you to do it. I'm just saying I get so many messages on either through comments on the channel or I'm getting emails from folks, including I just got one, I think last night from a lawyer saying, "Hey, look at all these judicial canons and rules that this judge is violating, and here's a way to go about doing it." So this is a way to go about doing it. It's a mechanism. So if you're motivated to, for those of you that are keep asking, what can we do about it? What can we do about it? I'm just showing you. This is what the statute provides for in Massachusetts, and they have a website for this organization. So whatever trust and confidence you have in that, if you're motivated to express your anger through that, then that's a mechanism you want to do. But I'm not the one that's telling folks to do it, because I don't want you guys doing it out of loyalty to me. I want you doing it if you're motivating your own heart to do it for Karen. Scarred up bones. Yeah, because Canton is Mayberry and they do it their own way. Oh, they sure do. Lisa Davy, you're saying I'm in California. Is something each human should fight this corruption. Finally, somebody's talking about the elephant in the room. Kathleen Martin, I agree with your grade C's of Judge Cannone F. Not sure what you mean. You're saying she deserves Fs across the board like I ruled? Graded it? Sue, you're saying there was a point where all judges were giggling, not anymore. Now judges are coming forward about Aunt Bevy. Yeah, I mean, judges got to be livid because this is making them look like a joke, right? Especially in Massachusetts. Yes. Wait, what? I've had that. We've talked about that 1 or 2 nights ago. I think it was 2 nights ago. Glamassus, yeah, the Commonwealth has lied for 3 years, hiding evidence, et cetera, and she's never sanctioned them. What? She has no concerns about it, right? Russian Aloha, you're saying the judge has an agenda. She's close to the McAlberts. I mean, boy, are they connected in that town or what? The McCabe's and the Alberts. Coffee Cake saying, I wonder how many complaints have been filed against her since this whole thing, and the rest of the attorneys as well. I don't know. We won't see that specifically from a judge, like I said, but we'll see the report in September how many were filed against the Superior Court judge, and I bet you pretty much everyone was against Judge Cannone. John Corney, you're saying there's Norfolk County, not just Canton. Alfred Dallaby, you're asking, precluding the FBI expert has no plausible basis in law. It's beyond reversible error. I agree with you totally on that. It's bias and precluding defense from presenting a defense. She's subject to justin by the CJC. Yeah, so I mean that's one of the things that, like I mentioned, the things that stand out is really huge. Is keeping out Easter. That's a massive, massive reversible error thing. I mean, that's just going to get bounced. If it doesn't get bounced by these courts in Massachusetts, it'll be done by the federal courts. if there's a conviction on anything. While Glamis Sue says, I have 4 notebooks from pretrial motions through yesterday. I'm sure I can go through them and provide a comprehensive list of items. Well, that sounds very phenomenal. I'd be happy to see that if you want to email it to me. Gilly, you're saying we know Morrissey's emails on the private server and his text. Defense filed to get these communications with a special master. Hank said, "Oh, no stuff. It's been deleted for after 30 days." Yeah, there's so much shady stuff going on. Yeah, wouldn't it be something if Brennan and the judge and Morrissey were all communicating via Signal, and then they act like this is such a nefarious act to use Signal? Salt and Pepper's judge practicing law from the bench. Yeah, when she's acting like a prosecutor, she is. She's not supposed to, but when she acts like a prosecutor, she is. That's what I would say. Technically, she's not, but when she's acting so one-sided, I say that is. Richie Blackmore from England. Judge Cannone, you're a DA department. You're a district attorney. Okay, the department isn't making the state of Massachusetts look good, making the state of Massachusetts look corrupt. Yeah, it certainly does. Yeah, Jam, that's true. It shut down defense arguments on several occasions, violating the right to be heard. Most recent with the response to ARCA, unreasonable time limits on motions and argument. Yeah, it's just having such a short closing in the first trial. It's Olivia Nile. Have you seen what former Massachusetts Judge Caroline Erskine has been saying on Twitter about Bev's conduct? Now, Twitter's now X, obviously. No, I have not. Carol Erskine, I'll write that down. Okay, thank you for doing that. My email, jurytrialmentor@gmail.com, or you could just do steinbecklaw@gmail.com. Mentor is MENTOR. Dark Nays, when Dr. Wolf mentioned the interest of the feds, that was Bass no longer touched subject. Her decision to let them in shows, in my opinion, the feds scared her. I think that's the only leverage that came out. And I credit Dr. Wolf for having the presence of mind to bring that out. I tell you what, Dr. Wolf with Brennan is going to be even more, I would say, just as riveting to see as this is what's going on with Jen McCabe. You really see the personalities of both those two come out between Dr. Wolf and Hank Brennan, and Hank doesn't have a chance. Yeah, Beth, I want to know what connection Morrissey has to get the 227's timestamp removed. Howie Carr said Morrissey used taxpayer dollars to pay off a foreign national. Yeah, Howie Carr, he's a funny journalist for the Boston Herald, I believe it is, and that is what that's what a comment he made about that. Yeah, I saw that today. Well, think about this. Ian Whiffen, he's been a longtime police officer as well. So it's sort of like that juror they had that's been a cop before. Cops will generally protect cops. Yeah, Glam sues. Bev refused to allow an FBI expert in geofencing and proper procedure. Meanwhile, she allows fools that have zero knowledge of dog bites. Yeah, Ava, judge choosing someone they know is sympathetic to the Commonwealth. That'd be a clear ethical procedure violation, not prioritizing judicial duties. So, and if she's picking the four person, guess what? That four person she's picking, is she screening notes beforehand? I just don't trust any of those folks working up there with the raffle wheel for deciding who's going to be kicked off because they're ready to deliberate and they need to get rid of alternates. Mystical Maven. Last year she started coughing. That was Coach Delally. Yeah, I dealt with a prosecutor one time. That was what he was doing to the star witness of the case, coughing when he wanted him to play dumb and say I don't remember. Yeah, Bluebeard DNA. We did see that. I covered that 2 nights ago on my live stream. So you want to go back and see that. Apparently you've already seen that on other channels as well. Clerk, too cute. You're saying if the Commonwealth's long game is to drive long mistrials, keep the clock running. What is the best way for Karen and the team to combat that? Just make sure. Just make sure you keep calling the judge out on all of her biases and prejudices against them, the denial of evidence from coming out, the way they can cross examine, all that kind of stuff. Keep having sidebars. They're way more aggressive than they were last time, so that's a good thing. And then you just got to make sure you nail your closing. Despite her keeping out much evidence, I would renew that thing with the FBI agent Easter as well. Cite case law. Thanks, Nick. Hey, by the way, I don't need your money. Just give it to the Karen Reed team. Also, I got an email today. Somebody was asking me, hey, they can't submit payments through any of the supporting apps or websites or whatever from being out of the United States. So somebody from South Africa. So can you all put that here in the live stream, how you can donate money if you're out of the country? Oh, thanks to Ann Smith. Yeah, obviously, Carl, I'm not a formal kind of guy, except when I'm in court. Carl's fine. Totally. Trichius, do I have any guesses to how the verdict will go this time? I know it's early, but curious what you think. I think it's going to be a win across the board, not guilty across the board. At worst, it's going to be a hung jury. I don't think there's going to be a hung jury at all, including worst case scenario. There won't be a hung jury on the murder charge. That'll be taken care of as a not guilty across the board. So, Corey, you can't imagine how frustrated Jackson is with the judge constantly interrupting when questioning Jen. Yeah, he's being tag team. You got two DAs on the other side, the judge and Brennan. I bet the Alberts and McKays wish they'd used Signal. River Birch, anyone else notice that Jen would look at the jury when she's telling the truth and look at the judge when she wasn't? There was some of that going on. Or look straight ahead, not looking at the jury, especially like with the FBI and stuff like that, different times when that questioning was coming out. Man, that whole thing about as a little girl with an ice cream truck telling your neighbor, I mean, that was like, I'm still thinking about that crazy statement. Long lit, why do I think the feds were keeping ARCA updated on witness testimony during the first trial? Maybe it was because it, if necessary, mention that, and I don't know if they're notifying them of substantive stuff or just like logistics. Hey, it looks like they got through this witness. This is what's going on. This is what their experts said. So keep in mind. It looks like the feds really want to help the defense in the sense that they realize Karen Reed's getting railroaded. So that leads me to believe that they didn't get anybody to roll over and fess up that we know of, but I think it really shows that they know that Karen Reed is not guilty, and there's other parties responsible for the death of John O'Keefe. Reggie, can AJ say ARCA was hired by a different law enforcement agency? I don't think they're allowed to say law enforcement at all, just agency. That's what happened in the last trial. So they need to keep fighting on that. That's just ridiculous. Thank you. Appreciate that. Al Scholes, how much you want to bet Hank starts using Signal? He probably already has. I've had it for a number of years. I sort of stopped using it. Ava, you're saying the judge's decisions are based on personal beliefs, relationships, and external pressures instead of law and fairness. Then they are failing to give precedence to their judicial obligations. That is absolutely true. Judge has already said she's going to. She doesn't allow. She's expecting a vigorous cross examination. Why would you say that? Like, sorry, Hank. I gotta give him one here because I got the feds looking over our shoulders on this. So I feel too much pressure from that. But what I want you to do is just, I'm going to let you unleash whatever fury you want. Act like a complete maniac on cross examination. I'll let you get away with that. And what judge does that? It's just so bizarre. How can this even be real? You don't see this stuff even that crazy in movies. Stevie Howell, you can't wait to watch Dr. Wolf heckle Brennan again. Yeah. Isn't that true? Grifting Gamer, thank you. You're saying the entire point of this trial is to get a conviction on the lesser, so to drag it out so long a jury gets an idea of fair and closure. Juries do this all day long, every day to innocent people. You don't like our system, but Mary Lindsay, you're saying she's so predictable in everything she does, even when she coughs. You're saying, Megs B, you're saying the judge knows this case, facts of this case, and why she allowed Brennan to stand up there and gaslight and twist facts, then act all outraged. Yeah, it's weird. I've never seen so weird. Normally, judges say, "All right, sit down. I know what's going on. These text messages are just nothing but routine course of conduct between attorneys and an expert. No, no, Brennan, you're not going to be able to do anything about it. You sit down. Sit down. I'm not going to make a spectacle out of this courtroom." Russian Aloha. Funny that to go all the way to Canada for an IT guy to lie for the Commonwealth. They couldn't find one in the States. That guy was just came across really strange. Like I said, he looked like he'd been up all night. Um, Sammy Jonas, thanks. You guys need to keep your money though. In your experience, why would witness in Massachusetts case lie? Well, the thing is, there's been polls by some of those main polling companies. They say 86% of Americans admit to lying on a regular basis. All right. So if they're lying outside of court, they're going to lie inside court. I just went to see a court proceeding, saw blatant, massive lies going on, and nothing happens. A lot of it you can't prove, but I knew enough details and truth of the case. So I knew lies were going on, and so yeah, I agree. The jury should pick the poor person. I'd object to that as well. I don't care if it's in statute, whatever. I'd object to that as well. Denise Rose, Hank thinks he is the smartest person in the room. Dr. Wolf knows he's one of the smartest people in the room. I would say he's the smartest when he walks in that courtroom. He happens to have the same PhD as my wife, the exact same, different university, but same PhD. So much smarter than me. All right, what do we got here? Yeah, Suji E. Generous. So you're saying I can give 40 reasons in each category why she deserves an F across the board. That's a good one. Kathy Prosser, I am still hoping the whole case implodes before it's turned over to the jury and all charges get dropped. I think that's a good possibility. I think this whole thing, what came out in the other Carney case, I think that could really derail this case if the defense wants to use it. If they're paying money to harass Karen Reed to this other gal that was supposed to be being paid $1,500. Jen Lyon to the FBI literally blew your mind the way she can sit back on the stand and justify her lying nonsense. Yeah, so I mean, I was thinking about that more today. So keep in mind, she's sitting there saying that, oh, she forgot to mention the FBI, that there was 3 other people she talked to. And so it's like, how do you forget that? How do you forget that, say, the FBI and your husband's there? And as soon as the FBI leaves, you right away tell your husband then the truth. So when did you tell your husband? You happen to suddenly be thinking of that because you're telling your husband? No, the reason being you lie to the FBI because you know that shows that you're guilty and trying to hide your course of conduct. And I just said like I said last night, I wish defense would have peeled the onion on that back a little bit more. So you conveniently forget to tell the FBI who you just got done talking to on the phone, the 5 people you spun up. So she acted more panicked with the FBI showing up than she did with John O'Keefe missing, and John O'Keefe dead on the lawn there, right? She got spun up real fast. So why would she do that if she didn't have anything to hide? Toby Berdash, she gets an F across the board. Frankly, I think she should be disbarred. For those of you joining late, here's a scorecard across these areas. You can Google the Code of Judicial Conduct rules for Massachusetts if you're joining late, or if you want to go back to see this later. You can see the different things I graded her on. Pretty Murphy, guy with a lot of guts. That's the detective there, retired detective out of Canton. He's been very outspoken about this case. He'd be a great one to testify for the defense, but this judge won't allow it. Any kind of law enforcement to counteract the jokes they got for the prosecution. Yep, clerk, we need to bring back FBI retired agent Easter. Okay, Dottie Fergati, I donated from the UK and it went through fines. So yeah, I don't know why. Can you say which site that is? Maybe post links to Karen Reed funding in the description. I'll ask John to do that. He knows how to do that better than I do. Is something funny, Miss Reed, should be absolutely referenced in the complaints. Yeah, why is she mad because Karen Reed's smiling? Estrella, after trial, when this judge goes after them with sanctions, can they fight her? I would say there's not, for sanctions by a trial judge, I've never seen that be appealed in Massachusetts. I'm not sure if they could appeal that in Massachusetts. I believe they could, so they'd have to just be appealed. I think that's what she's going to do. She's going to try to get Jackson on the way out the door. Loopy Hinkle, with my stints in the legal system, it seems to me that judiciary is the most OP and unchecked system of government we have. Not sure what you mean by OP. Sorry if I'm not tracking that, but yeah, I mean, if you have judges that just do what they want to, and there's no check and balance during the trial, then yeah, they can get away with it. But I'm like Loki. I got to have faith in the jury system. It's very much a pro judge system of justice up there with the jury, because the judge has such a heavy hand in who's being kicked off jury selection. VW Salt and Pepper, I believe jurors are told to leave their notes after the trial. The judge and Commonwealth can review them to adjust their prosecution tactics. I wouldn't be surprised if that happens as well. I mean, that's absolute corruption there. That should not be happening. They should be under lock and seal. But yep, maybe they can come up with a list of alternates that way. I understand there's a part of the trial the other day when Jen was busted about lying to the FBI, that like 7 jurors they saw taking notes down. You know, what are the odds those 7 are going to be booted as alternates? I'd say probably pretty high, unless the prosecution, the defense can somehow try to neutralize who's randomly selected out of that raffle basket. And even then, they could try to trump up some reason to get them kicked off, just like we had in the last trial. Joanne D, I wish all the lawyers would get together and show the corruption. And you're saying I'm the only one that calls out Cannone. Yeah, I wish that as well, but we'll see. Maybe they're going to keep seeing how bad this is getting, and more people will stand up and say something as attorneys. Lucas Knight, you're a little concerned about the judge interfering with the jury by means of directives and advice. Just how about her overall general attitude, the way she's snarky and condescending to defense? Antonio Carrera, I don't think the Norfolk DA tries this again without fixing the jury again. Denise Rose, anyone other than Hank confirmed the feds are done with their investigation? Not that I've heard. Goes outside of the U.S., YouTubers receive funds through their PayPal and Buy Me a Coffee accounts. Yeah, I'm not trying to get money here on YouTube. I'm not asking for money, but I'm talking about how do you get money to the Karen Reed folks to support them. Don't send me money. Send Karen Reed's team money. I saw something that they have like buy a lunch or something like that for $350. You can buy them their lunch for the day. Glamous's Jen's attorney is Kevin Reddington, who's an excellent defense attorney. Okay, well, they were to bring that out that that's her attorney and he's there in the courtroom. AJK, ice cream truck conjured up thoughts of a scary David Lynch film. I don't know what that is, but some of y'all might know. Mishap. Misha, sorry. Why doesn't AJ ask JM, do you deny it? D Mart, the ice cream truck was it for me yesterday. First, I didn't respect her for trying to mother her way to dignity. Compare the first and second trial. I would have kept going on and on about her whole demeanor change from the first trial, being very aggressive. You could even have asked her, it's like, why were you being so confrontational with me the last trial? Now this trial, you're being so deferential. You're telling me somebody didn't get to you? You thought of that on your own to try to change your image before this jury compared to how you did in the last jury? I'm just go on and on asking all kinds of details like that is what I like to do. Yeah, and this whole ice cream thing, really, was that a spontaneous statement or was that some kind of plot she calculated? Like, I'd ask her, who came up with that story? Valerie D, what do I think the Zoom meeting was regarding? I think that Zoom meeting had to do with court security. Like maybe she's going to get special law enforcement escort from her house to the courtroom. Nina Stanek, if the 911 call was sped up, can the defense ask for it? Well, they didn't even play all of it. As last night's live stream, I showed that they didn't play the whole tape, and they played it I mean, granted, we're hearing it through the not maybe as clear as the jurors, but it sounded very much jumbled and not very audible, and we didn't hear the whole tape. There's a lot of it that was left out. So I hope the defense circles a wagon on that and gets a better copy introduced to the jury, because that's a smoking gun right there. Okay, Linda Mon, thank you. Yes, I don't need money. And the ads here are for YouTube. You cannot avoid YouTube ads unless you get YouTube Premium. So yeah, save your money also for YouTube Premium. You'll never see another ad unless they have ads internal to their own live stream or their program. DKC going back, trying to catch up, just cannot believe. Seriously, this judge rules, comments, huffs, puffs, rocks, swirls. Who could possibly take this court seriously? Colin, you're asking, is having meetings with the prosecution who takes no notes like using Signal? Yeah, you could say it is. So, like I say last night, I think they might have had her be coached through her attorney. If this is a really good defense attorney, this Reddington, Hank could have given her the list of questions and gave suggestions of how she's supposed to clean stuff up and given it through her attorney, and then her attorney preps her and rehearses stuff for her, and or else he's there with them, and then they just do it in front of the Hank, and then her attorney's doing the one asking her questions. So there's ways to skirt around to try to trick and keep out the details of how she was prepped. But she was prepped massively, and I'm telling you, they are not being clean on that. So that's something I'd hit on tomorrow. And I'd keep going down the rabbit hole on that. Young Black economist, I don't know what questions the feds were asking Janet made her uncomfortable to continue. Yeah, I don't know if the judge kept that out, if there's some kind of motion limit ahead of time. But yeah, I would have asked him, what were they asking you? Mr. Monk's Undercity reporter Jess Machado really watches jurors. She said the foreman in trial one stood off from the beginning because he wasn't taking any notes. Will they overcorrect and take a ton of notes now? That's each juror's independent, so I don't think that we can predict that with any accuracy. JM, you're saying Feds provided info they wanted to evaluate ARCA, so Feds added info about DNA and outstretched arm theory to keep them updated. That's true because they did not have the prosecution theory that time, so then they had to pass that through to the ARCA team. And so the ARCA contract was not even over at the time this was going on. Maybe the contract was over and they're still updating it. I'm not sure, but that'd be interesting to know. Yeah, let him be angry with ARCA. He'll get chewed up by Dr. Wolf. He'll just get laughed down, smacked down by Dr. Wolf. Melissa F. Yeah, her guilty conscience. Shouldn't she be happy that they were trying to solve her friend's case? Interesting. Gilly says that your bestie lives on a military base. When we call her husband when he's in training, the military makes us use Signal. D-Mart, I think the worst of the agent may be an issue relating to the feds. That's what I said yesterday, that use of the word agent is particularly exclusive pretty much for the feds, not for any state or local agencies. Nina Stanek, if the 911 call is sped up, what can the defense ask for? Thank you, but please keep your money. I would say they need to play it. Well, I would have objected to it being not complete, and I objected to it being only partially presented. And otherwise, I'd try to show the rest of it during the defense case in chief. Stevie Howell, the other day, the judge parroted Hank about deleting over 100 messages when there was no proof of any number. Yeah, Dr. Wolf, he didn't know how many, he didn't keep track. He's not counting them, and it's all logistic stuff. So it wasn't significant in any way, shape, or form. But Brennan just stood up there making it sound like he had just done something super tragic, awful, like he was some kind of criminal on the stand for murder. Alfred, again, you're saying if the judge acts like this out in the open, imagine what's going on behind the scenes. That's what I'm saying. The kind of communication that could be going on is very suspicious. Brandy K, you're wondering if the other judges there at the courthouse are embarrassed of her and how she's leading this. Grace, can the Allen cross Jen for days? Is there a limit? Well, you don't want to keep rehashing the same stuff. The judge will cut you off. Any judge will cut you off. Keep rehashing the same stuff. So you can only go through a certain length of time, and you don't want to bore the jury and alienate the jury as well. So I mean, you got to have proper tact and how much of the time you cross-examine them. I mean, just look at like Charlie Adelson. His direct exam was like 8 hours long. In his murder trial, he got convicted on. That was like the worst direct exam I've ever seen. Yeah, Loki's saying I stopped watching Law and Crime when all the super chats, the channel for laws news. I couldn't see it. They start doing advertising internal now, so that's why I can't use them anymore for live streaming. The sirens definitely ramp up for the defense, says Mel. I wonder if they're doing that to support the defense. They're like, hey, we supporting you. We're here on your side, or if it's to distract. I don't know. I've heard it both ways, but I initially thought it was to try to hurt the defense. Okay, Sade, you're saying apologies. I did not see the quick interview Karen gave after court yesterday. She said she did not ask McCabe to Google anything. So interesting. So that really puts it on Karen. Help show this was totally something done by Jen McCabe. And if I was Alan Jackson tomorrow, I'd make sure I'd brought that out that she's the one that wanted to Google this, and Karen never said anything of the sort. I'd grill her and it'd be really aggressive on that and make her really, through body language, show she's not telling the truth. Yeah, let's see here. Yeah, she was acting guilty with the FBI. Yeah, she's panicking. She's absolutely panicked, stricken. Not with a dead body in her brother-in-law and sister's front yard, but FBI shows us your house. Yes, that's something more to be panicked about. Oh, hey, one other thing I thought of just now. Back to ARCA, when Judge Cannone was arguing that they violated this about record retention and stuff like that, she cited Massachusetts Rules of Professional Conduct 1.15. I mentioned this last night, but in case you missed that, 1.15, when I looked it up, it has to do with attorney-client IOLTA matters, trust account matters. It has nothing to do with expert witnesses. So she was completely wrong on the law that she cited. So anyway, she's just looking for something. That's why if you're that wrong on the law as a judge, it just shows she's looking for something to gun the defense down on. Yes, I wish the FBI would charge RICO with the DA's office and law enforcement in Canton. If they find the evidence there, they could do that. Anna, you're right. There isn't even a motor vehicle incident report filed in this case. Yes, viewers can make a complaint during the trial, but that's up to you whether they make the complaint or not. I'm not asking you to make a complaint. Yes, Heidi Harflinger in Massachusetts Code of Conduct Canon 2, Rule 2.11 prohibits judges from manifesting bias or prejudice in their official duties. We just see that all the time, don't we? Al dente, the jury's not that ignorant. If Jen can lie so effortlessly to the feds and to the jury, they can see your testimony scripted. I'm telling you that I think this government case is just crashing and burning. They never got off to a good start. I mean, when you look at the opening of Brennan to his first witnesses just getting crushed on cross-examination, and his expert coming in looking like he's some guy out of some bad guy out of some movies from Europe, like a Jason Bourne or something like that. So I just think that then you got Jen McCabe and Roberts lying to the grand jury. Imagine that. You got Carrie Roberts lying to the grand jury, and then you got Jen McCabe lying to the FBI. I mean, everything's just like got reasonable doubt written all over it. Just miserable loser case for the prosecution, but Kissy G, why am I such a hateful person? You try to shade other lawyers on surviving the survivor. Now you're here. Just please ask these people to invite you on their show so you feel like validated. First of all, no, I'm not a hateful person of people. I hate injustice, as any of us should. And I did not try to shade a lawyer on surviving the survivor. I called out a lawyer who was feeding information from the defense team for the Adelsons. So if I'm standing for justice, I do need to call out people that are doing stuff and misleading other people on where they're getting their sources from. The sources were made to look like they're coming from the government sources when they were not. And so anyway, then don't watch my channel. If you really think I'm just not for truth, then don't watch it. Okay, choose your other channels. Choose to follow folks that suit your liking. So that's what we have, freedom of expression here. But I'm not gonna let some hateful person like you spew your hate on this channel. All right, Denisa Rose saying, brush your teeth and made over 5 calls in under 10 minutes. Finds John's and can't be bothered to get help beyond calling 911. Whoops, calling. Yeah, learning curves. Jen said her husband told him they could not drive with a broken taillight. How did he know when Karen had just showed up? He came down the stairs for testimony. Yeah, I mean, really? He came down the stairs. If he came down the stairs, why didn't he get his clothes on and drive the ladies around looking for him or call all their law enforcement contacts? They owned that town. Makes no sense. Verily, yes, agrees. F across the board for the judge scorecard. I didn't grow up in the South. I live in the South here now. Here in South Texas with my wife. Recently moved here. But I spent a lot of time in Texas in the military. And also when I left the military for a short break, I was here in Texas in private practice. Yep, that's a key point. I think Jen called Brian Albert within minutes of Fed showing up, but stalled for an hour and no call when John was missing. And then even then, when she got to the front yard there of Brian Albert, she never went up there. And keep in mind, Brian Albert is married to her sister, Nicole. She never even bothered to call them and frantically knock on the door and tell the cops, hey, you need to check in the house. They could all be knifed or gunned down, dead in the house as well. So we all know why that didn't happen. It's very obvious. Matilda, you're saying, can a juror, as Bev is speaking, objection, stating it would help them understand why was it sustained or overruled? I'm not sure I understand your question. Can a juror ask Bev, Judge Cannone, for speaking objections rather than stating it would help them? No, she's not going to listen to jurors. She doesn't want them to know the basis for the objection, because the basis for the objection would just be so much ash and trash from Brennan that we could then better analyze what the basis of it is for and explain it. But it's all this secrecy objections, and you don't know the basis for it. But it's not just done in her courtroom; it's done that way across Massachusetts. Definitely a heavy foot on the scale, per Leslie. Okay, original post. See, I'm not tracking that, but thank you. Yeah, have you ever seen more of a misfit band of clowns? Dangerous people. They're highly dangerous people that you got investigating the law there. This entire trial, the judge, all the cops involved, this court is an absolute joke. Yeah, it's how can you respect a court that doesn't uphold the law and yet grant folks a fair trial in their proceedings? Yeah, Mr. Monk's understudy, a jury was brought sidebar on Monday. I believe that's the one that probably said, hey, I have a surgery coming up, and that's why we didn't have court today, is my guess. Andy McIntyre, judges are appointed in Massachusetts. They're elected in other states, and my state's judges have to answer to the people running for re-election. Well, think about it. If you get appointed as a judge, that means you got all kinds of political connections. If you got political connections, guess what you're going to do? Take care of people that have put you into power. Can't an ice cream truck? Okay. Yeah, I don't trust the court at all. And that's sad. I wish we could trust the court. I don't, this doesn't feel good having a judge that's so biased. AJ Lowe, you're saying other judges are also starting to call Cannone out. That's what I'm saying. Don't wait till end of the trial to start complaining about this judge. We need to have these discussions, and you know that's why this complaint process is maybe slow, but maybe people can put some pressure on it if there's a massive support behind this effort to have her held accountable. Steven Schweitzer, I think the John O'Keefe shot the dog after he attacked him. No, I think he I don't know if he's carrying this weapon with him, but unless it was in the house, I guess the neighbors wouldn't have heard. If it was outside the house, I think the neighbors would have heard. But yeah, inside the house, they probably wouldn't have heard anything. Yes, I'm gonna do another live stream tonight. Cover the rest of Jen McCabe. LS, you're saying you're concerned that the jury instruction will be a huge problem again, and she will not clarify them again. Yeah, that could be a problem, but that's why there needs to be time allotted for the defense to explain them. So every single jury trial I've had, I'm actually holding up the instructions and explaining them very briefly and succinctly of what to do and how to make sense of those instructions. Now, these instructions they have there are from like the 1840s on reasonable doubt. So you got to help them explain that in layman's terms and common underday understanding of such terms. Corey, that's what I heard from other folks. I think on X we found it. Paul was doing something inappropriate, and that's why they made him move. Katrina, there's a Karen Reed Defense Fund. You can Google it. GS, no, I've not seen anything this bad. I've fought a lot of corruption in my lifetime, and a lot of that was in the military, bigger organizations. There can be a lot of that going on. And I've said people have no idea how political, i.e., corrupt, the criminal justice system is in numerous places across the military, as well as in states and federal courts. Constance Landers, yeah, Brandon's been trying to accuse all of the underhanded bill he's been doing. Yeah, it's just such a joke. He has zero credibility. It's all he's like a hologram. It's all projection. There's no substance. Yeah, Paul got moved because of some kind of mannerisms he was doing in the courtroom, I believe. That's what I'm hearing anyway. I wasn't there to see it firsthand. Avid Events, can defense ask to submit videos of Jen from previous testimony? She's denying now. I would try to use that for cross. If she doesn't admit to something, play a videotape of her. I don't know if the judge would allow it, but I've done stuff like that before in trials. Okay, I'm gonna go for, let's see, a couple more questions here, and then we'll shut down. So I'll jump on later tonight, and we'll cover part 2 of Karen Reed's case and the testimony of Jen McCabe again. Dolores Hamilton, can defense ask Jen if taxpayers are paying her lawyer? No, they would know that she's paying it on her own, out of her own pocket. Unless you're charged, you don't get a public defender appointed to you. All right, let's see. There is. Yeah, let's see. Ava, I'm hoping Hank's behavior ticked the FBI off, says Variant. Riverdale Pilates, did I give up on the Adelson's case? No, but that thing's gonna be delayed again as well. And so I'll cover that case as well. It's so demoralizing to think that we have to have Don Adelson 2.0 when she should have been convicted right alongside her son last year. Or actually, it was a year before. Man, time's flying so much. Yeah, the judge wants to get Jen off the stand, rushing Jackson. Yeah, I think that's true, Dolores Hamilton. Josie Lou, what happened inside the house different from what happened outside the house? Jennifer McCabe, there were several subliminal statements made, not fully taken advantage of. Yes, thank you. Do not need that support though, but FBI Good Humor ice cream truck. Okay. Kiska, you're saying Paul's wife was doing slit throat gestures the first trial. I don't know about that, but oh, hey, Defense Diaries podcast. Good to see y'all. And I saw you at CrimeCon last year, so good to see you. Maybe I'll see you at CrimeCon again this coming year in Denver. Yeah. So hey, what score do you give Judge Cannone? I gave her a score right here. I'll add it to the stage. I gave her an F for all these rules of judicial conduct. Do you have any score you want to give her an overall here? F. Yeah. Anybody wanted to give a score here? Oh, Dirty Bev says, I saw a ton of reviews now finally posted on this site, the Robing Room Judicial Review website about all judges under Judge Beverly Cannone. These reviews are about Karen Reed. Yeah, for everybody pretty much saying F, -0, all Fs, F, F minus. Ava, why are the feds line Hank and Bev to ridicule their staff like that? I mean, it probably makes sense. If I was ARCA, their general counsel or lawyer staff, I'd probably call up the feds, say, hey, can you put some heat on this prosecution and the judge to quit bashing our line of work. Bob, yeah, Bob, defense diaries. Everybody says F. Bob, you still with us there? All right, with that, I'll go ahead and see you guys a few hours from now. Probably be closer to 10 o'clock is my guess, somewhere between 8 and 10 Central Time. And it all depends on what we get done here. But thanks for supporting the justice for Karen Reed, and hopefully I'll see y'all later.